We're about ready to start. Hi, I'm Jordan Flanders. I'm the lead McPherson in the Food Law and Policy Society organizing this panel. Is big food the new big tobacco? And I'm just going to introduce Dave Watnick, our moderator today. Dave Watnick is a third-year student at FLS. Maybe you might know him. He is at the University of Michigan, and his primary legal interests are torts and immigration. He spent the past summer working at Watnick, a plaintiff's firm in South Carolina. He worked on cases concerning tobacco, asbestos, terrorism, pharmaceuticals, defective products, and catastrophic injuries. Next year, he'll serve as a clerk for Gilbert Merritt.
Great, thank you. Thanks everyone for coming today. Let me introduce our panelists and then we'll get started. First, you're going to hear from Dr. Robert Lustig, Pediatric Endocrinologist at UCSF. He's Professor of Clinical Pediatrics and Director of the Weight Assessment for Teen and Child Health Program. He practiced in the field of neuroendocrinology with an emphasis on the regulation of energy balance by the central nervous system. His efforts to establish that fructose can have serious health effects on humans, and especially children who consume in too large amounts, have brought him great public attention, including a viral video on YouTube from 2009 called Sugar, the Bitter Truth, and a successful book called Fat Chance. Pierce Gore is of counsel to Pratt & Associates. He specializes in civil litigation, consumer protection, and business and employment disputes. Has experience in class action in a wide variety of businesses, filing suits against Kraft, Nestle, Frito-Lay, Hershey's, Chobani, and ConAgra. Danny Chou is an assistant county counsel for the County of Santa Clara, where he supervises the health and hospitals impact litigation, social justice, and probate sections of the county counsel's office, and provides the Santa Clara Valley Health and Hospital Systems and the Department of Adult and Aging Services. He also oversees appellate litigation, affirmative litigation, and legislative affairs for the office. And Leslie Brueckner is a senior associate in public justice. She has worked in a wide range of practice areas, including Title IX, federal preemption, combat and court secrecy, objectively illegal or unfair class action settlements, workers' rights, consumer rights, and access to justice, and environmental protection. She now serves as the director of Public Justice's Food Safety and Health Project, which seeks to hold corporations accountable for the manufacture, distribution, marketing of food, and other products that endanger consumer safety, health, and nutrition. So thank you all for joining us, and we'll get started. That'd be great.
Thank you, David. Thank you all for coming. Thanks for the invitation. I really appreciate it. My job is to sort of set the table, as it were, about this food debacle, to try to explain why it matters. It matters to you and your children, and of course, what the law brings to the table. So first of all, I have no disclosures, no food industry concerns putting me up for this promise. This is a paper that came out last year called Profits and Pandemics. And what it said from Lancet, what it says is that when I went to medical school back in 1980, I learned the old medicine, which was about infections and the vector-less microbes. And now, unfortunately, people have to learn about the new medicine, which is about chronic disease and the vectors, multinational corporations. And just the same way bacteria learn how to get around antibiotics, multinational corporations learn how to get around walls. Here's the primary principle. This is the mantra that the food industry uses as its juggernaut, if you will, to basically obfuscate any other effects, any other chances for regulation of any sort. It's right here on this slide. This is Coca-Cola's Coming Together campaign from last year. And it says that beating obesity will take action by all of us based on one simple, common sense fact. All calories count no matter where they come from, including Coca-Cola and everything else with calories. So you can get your calories from carrots, or you can get your calories from cheesecake, or you can get your calories from Coca-Cola, or anything else with a C for that matter. It doesn't matter, because a calorie is a calorie. If you eat more than you burn, you'll gain weight. If you eat less than you burn, you will lose weight. Therefore, why pick on our calories? Go pick on somebody else's calories. Go exercise. Why pick on us? Personal responsibility. It all emanates from this statement here. Well, I don't believe in common sense. I believe in science. I believe in data. And the science says something completely different. What the science says is that some calories cause disease more than others, because different calories are metabolized differently, because a calorie is not a calorie. This is called nutritional biochemistry. I actually majored in this in college, then went to medical school and promptly forgot it. Went into it basically suspended animation for about 35 years, okay, only to come out and realize, oh my friggin' God, what has happened? This is the most important set of slides I'm going to show you because it makes the argument for why this is a public health issue. Here's a Venn diagram of the United States adult population. 30% obese, 70% normal weight. And the standard mantra from the Institute of Medicine, from the NIH, from the insurance industry, from the healthcare industry, and from the food industry is the following. 80% of those 30% of the obese population, those 57 million people right there, they're sick. They get type 2 diabetes, they get hypertension, they get dyslipidemia, they get cardiovascular disease, they get cancer, they get dementia. Those 80% of those 30%, those 57 million people, it's all their fault. And if they would only just diet and exercise, we could solve this problem. That's the mantra. That's what they say. Garbage. It's true. 80% of the 30%, those 80% are sick. That's true. That means 20% are not. 20% of the obese population are perfectly healthy. They live a completely normal life, die at a completely normal age, not cost the taxpayer a dime. They're just fat. Conversely, turns out 40% of the normal weight population have the exact same diseases as do the obese. They get type 2 diabetes, they get hypertension, they get dyslipidemia, they get cardiovascular disease, they get cancer, they get dementia, too. Not quite the same prevalence, but there are more of them. 67 million. So it turns out there are actually more thin sick people than there are fat sick people. When you do the math on that, that's more than half the US population. Okay, so this is a public health crisis. So let's go back to the last public health crisis we had to deal with, HIV. Everybody remember HIV? Sort of, maybe? Too young. All right. 1979, patient zero. 1981, the term AIDS gets coined. 1984, Gallo and Montagnier discover the virus. 1986, our Surgeon General, C. Everett Koop says, we got a problem. What year did HIV become a public health crisis? What day, what time? 1991, November 12th, 1991, at 10:30 Central Standard Time. Because that was when the press conference was held, when Magic Johnson declared he had HIV. And the whole world went, holy, this could happen to me. Because up to that moment, it was about the gays and the addicts and the hemophiliacs, and if you weren't one of them, it didn't matter. And now all of a sudden, everyone was at risk. Well, guess what? Everyone is at risk. This is a public health crisis. A public health crisis means public health intervention, not personal intervention, societal intervention. That's the argument. So the key to the kingdom is it's not about obesity. Okay, obesity is a marker for the problem, not the problem itself. The problem is chronic metabolic disease. The problem is diabetes, heart disease, cancer, dementia. That's where the monies go. So metabolic syndrome is its name, and that's where we have causation. Not for obesity, but for diabetes. This is a study that we did last year when we looked at the entire world's diet and asked, what about the world's diet predicted diabetes? And the answer was only sugar. If you consumed 150 calories extra per day, your diabetes prevalence went up by a total of 0.1%. But if those 150 calories happened to be a can of soda, it went up 11-fold by 1.1%. And this actually satisfies the criteria for proximate cause. Dose, duration, directionality, and most important, precedence. Wherever sugar changed, diabetes changed in the same direction 3 years later. That's what you need for proximate causes. This satisfies the legal definition. So what's happened to our diet? Meat, down 10%, because we're all told to go low fat. Fruits and vegetables, exactly the same. Grains and baked goods, up 1%, that's a problem because that drives weight gain. Dairy products down 2.5% because now we're all lactose intolerant. Processed foods and sweets, 11.6 to 22.9%. That's what's changed. A doubling in the last 30 years. And that's what's causing the chronic metabolic disease. And who is doing that? The food industry. So we have this. You all believe this. The question is, do you believe this? And the answer is, we have the data. the data that sugar is both toxic and addictive. Okay? These are the criteria that you need in order to effectuate changes in the environment from a public health standpoint. Sugar meets all 4 criteria. It meets unavoidability. You can't get away from it because 77% of all food in America is laced with it by the food industry for its own purposes. Toxicity, because we've shown sugar causes diabetes and causes heart disease and causes liver disease. Abuse, because sugar is weakly addictive in the same way alcohol is. And finally, externalities. That is, your sugar consumption hurts me because employers have to pay $2,751 per employee for obesity-related diseases, whether the employee is obese or not. That means that sugar meets the same criteria as tobacco and alcohol in terms of public health danger and public health regulation. So with that, I will stop and turn the podium.
Pierce, thank you.
Good afternoon, thank you for coming. When I was a lawyer at the legal appraiser firm in San Francisco, I worked on that tobacco litigation. If you don't know anything about that litigation, the end result of it was, how many of you, let's see a show of hands, have seen these horrifying graphic ads on television aimed at teenage smokers trying to, the ad where the woman, the beautiful young girl says, I started smoking because I wanted to look older. And then fast forward, she's got a breathing hole in her neck, and the tagline is, it worked. That was the result of that litigation. Our star witness in that litigation was former FDA Commissioner David Kessler. And so we're sitting around talking with him and drinking. At the end of that case, thinking he was about ready to ride off into the sunset, and we asked him, now that you've tackled the single biggest threat to public health in the United States and the world, what are you going to do with your free time? And he told us, we haven't tackled anything like the single biggest threat. The single biggest threat is food, not tobacco. And we were shocked by that. We asked him, what do you mean food? What are you talking about? And he explained to us that the modern packaged food industry takes the foods that you were familiar with, like apples, tuna fish, everything else, and twists them into a very tasty and very toxic cocktail, a stew of sugar, fat, salt, and chemicals that make the foods that you eat every day not just tasty, not just habit-forming, but literally addictive. David Kessler became convinced that packaged food would be a bigger threat to public health in the 21st century than tobacco was in the 20th century. So those of us who had worked on the tobacco litigation started thinking about, what can we do about this? These folks dedicate their careers to education and legislation. My career is dedicated toward litigation. I like hitting people in the face. That's what I do. I work with a group of 40 lawyers at 9 firms in 7 states, and we have sued every large packaged food company in the United States. It's a massive undertaking. You can imagine the fight these companies put up. But I want to tell you just a little bit about what's in the food that you're eating so that you can know why we're doing this. For decades, individual smokers sued the tobacco companies based on their having developed lung cancer, emphysema. Those cases all failed because the defense was based on personal responsibility, like Dr. Lustig talked about. So we knew we had to go at it some other way. We had to find a point of attack. And what we discovered is that buried in the Code of Federal Regulations, there are regulations on what you can say and what you cannot say on packaged food. And the supermarket is a sea of lies on packaged food. I'll give you 3 examples. We need a volunteer from the audience. You. What's your name?
Jane.
Jane, where are you from?
Davis, California.
Jane, do you eat healthy foods?
Hi.
Do you read the labels on the foods that you buy? Okay, I want you to read the label on this package of Dole mandarin oranges. You see where it says here, all natural fruit and juice?
Yes.
Okay, and then you can see the fruit in the package there. It looks like fruit and juice, right? Okay, what is that advertising slogan there, all natural fruit and juice? What does that tell you about the contents of this package?
It's all from nature.
Right. What about chemicals? chemicals and preservatives and additives. Would you expect that in here?
No.
Wrong. You knew that was coming. You get to the end of the ingredient list on here, and there's citric acid and ascorbic acid, which is manufactured in enormous industrial vats in China. Dole's defense, this case is going to trial, scheduled to go to trial, in front of Judge Chou in San Jose in January. Dole's defense is, and I'm not making this up, the all-natural refers to the fruit. The fruit was natural when it was on the tree. We can fill these containers with as many chemicals as we want. And the consumer should expect that they're in there because the all-natural applies to the fruit, not to the contents of this package. All right, Jane, you're doing great so far. You ever seen this?
Yes, I eat that.
Good for you. It's healthy? Of course it is. We're going to eat it if it weren't healthy. You know what this is?
Yes.
Okay, this is a really, really easy one. Which contains more sugar per ounce? This or this? Which one, Jane? Wrong, Jane. Wrong again. The sugar per ounce is exactly the same in Chobani yogurt as it is in a Coke. There are 12 teaspoons of sugar in this can, just as much sugar per ounce. So that means that in the ingredient list here, Chobani would have to disclose the sugar. They'd have to tell you, if they were going to put as much sugar in a cup of yogurt as in a 12-ounce can of Coke, this is 6 ounces of yogurt, this is 12 ounces of Coke. Same sugar per ounce. And they're selling you a healthy breakfast here. I want you to go to the ingredient list right here at the bottom of the back and tell me where the word sugar appears. It's not on there, Jane. Evaporated cane juice. That sounds kind of healthy. Right? Juice. Juice is healthy. Right? Evaporated cane juice. Chobani's, this case is up on appeal in the Ninth Circuit Court of Appeals. Chobani's defense, and I'm not making this up, I couldn't think of this, is we don't add sugar to our yogurt. We add it to the fruit at the bottom of the cup. So all you have to do to avoid that sugar is just skim the yogurt off. Don't eat that stuff at the bottom.
That's why we eat it, though.
Exactly. Last one. All right. This one is a little tougher. You may control this one. You know what this is?
Spray oil.
Exactly. All right. I want you to go to the ingredient list and look at the last ingredient on the list. Propellant. Now, what would that be?
Not food.
I mean, there's a regulation that says you have to call the ingredients in packaged food by their common or usual name. So the consumer can go, okay, all right, that's fine. Propellant is a mixture of butane and propane. That's lighter fluid. ConAgra's defense is the propellant is what makes the oil come out of the can. And most of it evaporates. You don't actually cook your grandchildren's pancakes in lighter fluid because most of it evaporates. This case is also up in front of the Ninth Circuit. That's what we're dealing with. Don't eat packaged food. If you can come away from this today with one lesson, eat whole foods, eat natural foods, eat simple foods, locally grown foods. This stuff, it's like when you go to the casino in Vegas. The safe bets are the stuff around the outside. In the supermarket, the healthy foods in the produce section, the dairy section, the fish section, stuff in the middle, it's unhealthy, and the labels are filled with lies. That's what our cases are about. We have 60 cases pending in the Northern District of California and other states, Massachusetts, Arkansas, around the country. I'm going to use up my 8 minutes and then some. All right.
Yeah, you're right.
Well, thank you guys for having me. I'm going to talk a little bit about food litigation from the government perspective. I currently work for Santa Clara County, where I oversee impact litigation, where we look to use affirmative litigation to help change policy. And before then, I worked for San Francisco, for the San Francisco City Attorney's Office. And I've had the pleasure of working for probably 2 of the most aggressive public entities who are looking to use litigation to try to affect social change. And for both counties, health and nutrition are at the top of the list of what's important. And part of the reason for that is in California, counties happen to be the health providers of last resort. They're basically the safety net. And we're basically at the front lines of dealing with this health and nutrition crisis. And as a result, the counties I work for are looking aggressively at different ways to approach the problem. And they've decided that it's important to adopt a multi-pronged approach that looks at all options. And for better or for worse, litigation becomes one of those important options. And in looking at litigation, it's kind of interesting because typically governmental entities are reactive. But what ends up happening in the health and nutrition arena is that counties often are very innovative. They want to enact new laws that hopefully can change the way things are done. And San Francisco and Santa Clara County in particular are very aggressive in passing new innovative regulations that frankly threaten the food industry and threaten the various industries. And what that does is when the county does that, we know full well that the likely result is going to be litigation. So in essence, the local governments are inviting litigation in order to make a point and to try to change things. The other way that we use litigation to sort of advance social policy is we do affirmative cases. And one of the benefits that governmental entities have over private parties is we have better tools at our disposal. There are certain statutes that give us civil law enforcement powers that we can utilize to kind of maximize the effect of our litigation. And that type of government litigation is often more threatening to the companies and the private lawsuits because we have a lesser burden of proof in most of the cases. So I'm going to talk a little bit about both types of litigation that we often work on. On the defensive litigation side, local governments, and I think governments in general, are recognizing that the key to changing and improving people's eating habits and nutrition actually has to do with somehow changing the environment that they live in, as well as the social norms that affect what they eat and what they choose. And one of the areas that local government entities like San Francisco and Santa Clara have been thinking about how to change the environment is you want to start forcing people to think about their health when they choose their foods. And one of the ways that that can be done is by when they buy it, you have warnings, you have labels, you have posters saying, think about what you're getting, think about how much sugar it is, think about what that sugar means to your health. And both counties have sort of taken efforts to try to pass those type of laws and try to make consumers really think about what they're buying. But what you find is that those type of regulations engender a lot of opposition. This is both in the tobacco arena and in the food arena. Companies realize that if one local entity passes a law that seems to work and seems to be effective, you're going to get copycat legislation. And what happens is that when one local entity passes a landmark regulation or a landmark law, the industry sues. It happens in tobacco all the time. It still happens in tobacco, and it happens with respect to the food regulations. Probably one of the most recent examples that we were involved in was menu labeling. In 2006, New York City adopted the first menu labeling ordinance. It only included calorie counts. In 2008, Santa Clara and San Francisco passed their own menu labeling ordinances. But those included much more than simply the calorie counts. They included stuff like saturated fat content, sugar content, stuff like that, so that when you're going to a restaurant, you have a better idea of what you're purchasing. Not surprisingly, the industry sued us. And I'll talk a little bit about the theories and the barriers that we have to deal with in doing those regulations. And then what often happens is when the industry realizes that they're going to have a difficult time winning the lawsuit, they go up higher. They go to the state or they go to the federal government to enact superseding legislation that will preempt the local ordinances. And that's what happened here. While the lawsuit was pending, the state of California passed its own menu labeling law that only included calorie counts, and it was part of the Affordable Care Act. They threw something in where they included menu labeling and limited it to calories and limited it to a certain subset of restaurants, and that is now preempted the field of menu labeling. And usually what we find is when we try to adopt these regulations, particularly dealing with labels or displays, the two most common challenges that we're seeing are preemption and First Amendment. And interestingly enough, these are the exact same arguments that are typically used whenever there's attacks on tobacco regulations of the same types. Preemption is a big problem. It makes it very difficult. In theory, under our system of federalism, the theory is that local governments are the laboratories of democracy, and they should have the opportunity to try innovative new experimental laws and and see if they work. And if they work, the hope is that other people will copy them and it'll go nationwide. Preemption sort of goes exactly against that principle. The idea is that there's a need for uniformity and that the federal government knows best or the state government knows best, and we should limit what the local governments do. And in the food arena, there's a very, very strong federal statute, the Food, Drug, and Cosmetic Act, that really limits what type of labeling you can do with respect to food. And the definition of labeling is very broad. It's not simply the stuff that you stick on the food packaging. It includes any information that you provide at the point of sale, and that with respect to a specific product that explains its contents. And as a result, that puts a huge barrier to what sort of measures local governments can take to try to force consumers to think about the foods, think about their health when they're buying food and beverages. And that's a barrier that we're always up against when we're trying to figure out what sort of regulations we can adopt that can help improve people's eating habits. The other big area that is becoming, frankly, more and more significant, and we were actually talking about this a little bit at lunch, is the First Amendment. There has been a big push in the last decade, particularly with this U.S. Supreme Court, to truly broaden what, first of all, the notion of commercial speech and the notion that commercial speech should be protected. It sort of ties into the notion that corporations should be people that should have the same individual rights that all of you have. And what you've seen is an expansion of that notion that commercial speech should be protected, and that whatever the government compels retailers to do and to display in terms of speech has to be purely factual or uncontroversial in order to actually be forced to make that type of speech. So this has been used very well by tobacco companies and by food companies to sort of prevent the sort of displays that can really affect people's buying decisions. And, one of the recent examples is the tobacco cases where they've invalidated the very graphic displays or graphic labels that local entities or states try to put on cigarettes. And that's been invalidated in the First Amendment grounds. So those have been a pretty big barrier to regulation in that front. On the other end of the spectrum, governmental entities also look at affirmative litigation and look at ways to force these companies to change their ways. This was a big deal for the tobacco litigation. I think really what was kind of the straw that broke the camel's back was when local entities like San Francisco, Santa Clara, and the states got together and sued the tobacco companies for RICO and a whole other slew of actions. I think that's what you were involved in, Pierce. And that, that was sort of a landmark case that really changed the whole notion of control, of tobacco control. And it really changed the dynamic of the battle against tobacco in this country. The hope is that there would be similar litigation efforts that we can use in the food industry area, but there's greater barriers there. For one, there's a lot more products that you have to deal with. It's also much more difficult to establish causation in the food industry area. And there's also less of the surrounding harm. Frankly, secondhand smoke was a very powerful argument against tobacco because it not only harmed the person who smoked, it harmed the people around them. That's not as easy to show with respect to food. And one thing we find is that lawsuits by private individuals really have a difficulty with these barriers. And the recent roadblocks that are placed on class actions with CAFA, the Class Action Fairness Act, as well as the Walmart decision by the U.S. Supreme Court, made class actions much more problematic and much more difficult to bring. And that's where the governmental entities come in. We have the benefit, at least in California, of certain laws like the unfair competition law and like false advertising laws, where we don't have to prove injury. We don't have to show fraud or particularity. We don't have to show actual deception. We just have to show that it's likely to deceive. Or we don't have to prove stuff like reliance, causation, and damages to get injunctive relief, restitution, and civil penalties. And San Francisco in particular has been very effective in using these laws to try to change things. One example you might have seen in the news is with Kellogg's Cocoa Krispies. During the H1N1 flu epidemic, they put on their packaging, it helps immunity. I kid you not.
Danny, I'm going to cut you off there so we can get questions left.
I'm going to take credit for that. I work with Francesca Guessman in the City District Attorney's Office, and we filed the motion for cease and desist with David McKay, the head of Kellogg's. So that was the San Francisco City Attorney's Office did that.
Yeah, and it was actually a special power that the city attorney has in their state law to send a letter to a retailer that requires them to provide the evidence to justify their claims. And if they don't, they're subject to injunctive relief and civil penalties.
I'd say this is the first panel I've ever been on in my 20-plus year career where we're actually running on time. Everyone really running minutes. So kudos to everyone. So what is going on here? We're living in one of the most affluent countries in the world. And frankly, our food system it's a catastrophe. It's a catastrophe on every level. It's a catastrophe on the levels that Dr. Bob described here. Is it Rob or Bob? I never know. Rob. These food companies are pumping out poison. And people are eating it in droves, especially poor people who can't afford the stuff that's on the edges of the supermarket. We've got an obese population, a sick population. We've got governmental entities that are struggling to hold some of these corporations accountable, but there are numerous barriers at every level to government having any effect, any serious effect on this. As he just pointed out, federal regulations that in this area often will preempt state lawsuits and also can preempt lawsuits in the court, such as the ones that Pierce brings. So we have a situation where you have often multinational corporations pumping out poison. You have a government that barely regulates, at a very minimum, the regulations that are put out are inadequate. And even those regulations often either can't be adequately enforced or they preempt other efforts to enforce things. We've got the state tort system, which, despite the noble efforts of a lot of lawyers like Pierce, can only affect the merest sliver of this. The Supreme Court is cutting back on the ability to continue to bring class actions. And the real problem here is that the food industry and big agriculture is one of the most powerful lobbies in the country. And they control Congress, they control federal legislatures, they control the regulatory agencies that are supposed to be protecting the public from the food. And we're really in a very, very bad situation. I think the only way, ultimately, for people to save themselves from the type of poison that's being perpetrated in our supermarkets is by public education. And it's just so striking to me that we're here at Stanford Law School with some of the most intelligent and affluent people in this country, and in the box is Coke, right? And here I spend most of my time doing food safety litigation, and I don't have Coke in my refrigerator, but I've got Diet Coke, and that stuff is shit too. And I can't even take my own advice. I was eating sugared cereal this morning, and you know what I did before I came? I was like, what am I doing? I dumped it out loud. But I want to tell you that all of this is, to me, pales in comparison to the biggest looming crisis in this country and worldwide, which is related to factory farming. 50 years ago, dairy, beef cattle, chickens, pork, all these animals were raised under fairly moderate conditions. But in the past 50 years, we've seen the rise of these gigantic factory farms, the industrialization of animal agriculture. The term is CAFOs, you've probably heard it, concentrated agriculture feeding operations. These are these gigantic entities where we now get almost all of our meat and dairy and pork in this country. And the CAFO industry is one of the most powerful industries in this country. And the problems, when I started out our food health and safety project, I looked at all the different things that were going on in America. And it seemed to me that this was the worst of the worst, because what's happening there, first of all, put aside the fact that the animals are being treated under conditions that if your dogs or cats were treated this way, you'd be criminalized, you'd be thrown in jail. Horrendous conditions. Put aside the fact that the food that's being produced is often adulterated and causes 23,000 cases of food poisoning a year from salmonella and E. coli. Put aside the fact that A lot of the dairy and the eggs and the milk is pumped full of growth hormones. Put aside the fact that the workers are treated so badly that often they're forced to stand on in poultry processing plants, we've had cases where workers are standing in, forced to wear diapers because they're not allowed to take a bathroom break for 12 hours a day, but they have no power because most of them are illegals anyway. Nobody else would want to work in those conditions. Put aside the fact that some of those workers are coming down with MRSA, antibiotic-resistant disease, because they're exposed to all the antibiotics. Putting all of that aside, all of these problems aside, 4/5 of all the antibiotics in this country go into the non-therapeutic use of antibiotics in agriculture. So what does that mean? That means that antibiotics aren't just being used to keep the animals, make the animals better when they're sick. Animals in this country are being pumped full of antibiotics from birth because they're being confined in such close conditions that unless they're given antibiotics from birth, they're going to get sick and die. What's happening is that this is causing the growth of so many antibiotic-resistant organisms. And the World Health Organization, among other things, the AMA, every kind of medical group you can think of, is declaring this a world health crisis. We are on the brink of rendering antibiotics useless in this country for a lot of diseases. And what does the FDA do? Basically nothing, because they are in the nursing industry. So what we decided at Public Justice, I've been a litigator there for over 20 years, we've had a food project for 5, is to try to go after the factory farms. And how do you do that? It's difficult. Animals can't sue. Individual consumers who get sick can't really bring in a viable lawsuit. The workers can't sue because they're disempowered. What we discovered is that the best way to go after the factory farms is using environmental litigation. The way that these farms would have to deal with the massive amounts of waste, it turns out violates the Clean Water Act, it violates the Resource Conservation Recovery Act, violates the Clean Water Act, Clean Air Act, you name it. So we've been filing lawsuits against a bunch of different factory farms. We've had huge lawsuits going against 5 industrial dairies in Washington State, and we think that those lawsuits might make a big difference. I like to think of it as it's like going after Al Capone for tax evasion. It's not the biggest problem, but it's the best legal hook. The other thing that we're doing that's related to this, and this is just as scary as all the rest of it, is that big agriculture is pumping millions and millions of dollars into the states to have the states pass so-called ag-gag statutes. These are statutes that make it a crime to whistleblow in a factory farm. And the genesis of this is that groups like the Humane Society have been sending people into factory farms. They get employed undercover as a worker there, and they'll do undercover videos. And these kinds of videos have led to huge meat recalls in the past. And they've really started to change the public's understanding about where this food is coming from. And I tell you, with the limits on litigation and with big agriculture being, having its grip on Congress and the state legislatures, the only way that anything is going to change is if consumers understand what's happening with their food, which is why what he's saying is so important, which is why it's so important that we defeat these ag-gag laws. So I'm currently involved in 2 constitutional challenges, one in Idaho, one in Utah. They're both going well. There are 14 other states with ag-gag statutes on the books. There are ag-gag statutes in the pipeline in almost every other agricultural state in the country. That's where the rubber's going to meet the road, because if people don't learn about what's going on in these factory farms, it's going to keep on happening. I have so much more to say, but I'm going to sit down. Thank you.
All right, well, thank you all. We'll open it up to questions in a second. I think all of you talked about we basically need to change consumer choices, and that starts with people knowing what they're consuming. If we think about tobacco in the last 30 years, we have many fewer people smoking, and I think large part of that is people know uniformly how bad tobacco is for you. But not everyone has stopped. And it would seem actually tobacco is going up. Right now, it's resumed going up again. And in the case of tobacco, this is a product which is completely unnecessary. You can cut it out of your habits, you can save money. If you're going to cut out bad foods, you need a substitute. In many cases, it's unfortunately going to be more expensive. So that factor combined with the example of tobacco, where even if you know how bad it is, you may not stop. makes me very skeptical. I mean, how much are people going to need to know before their habits really change?
Well, let me start. Education alone has not solved any substance abuse, period. Did Nancy Reagan's just say no work? You can tell somebody what is going on, but if you're addicted, you can know that that thing that you're addicted to is ruining your life, completely destroying your family, just devastating your economic situation and putting you at risk for death, and you can't stop. And that's what addiction is. That's the definition. And the point is that you cannot use education alone. For every substance of abuse, we have two different modalities. One's called personal intervention, for lack of a better word, we'll call rehab, and societal intervention, which, for lack of a better word, we call laws. Rehab and laws, rehab and laws. For smoking, for alcohol, for cocaine, heroin, you name it, pick your addiction, you got rehab and laws. Even for gambling and for sex, we got rehab and laws. For sugar, we got nothing. For any of the other things in any of these packages, we got nothing. And we need both. Public education is absolutely required, it's necessary, but it's not sufficient. So we start there, and that's what we're doing, and that's what I'm doing, and that's why I'm here. But the fact is, it will not be enough, and we need more. And that's why you're sitting in the audience, because the laws come in the orders.
And if I can add to that, this is a problem that we in Santa Clara County actually grapple with, because even if people want to make healthy choices, particularly among the lower income community, they often don't have access to healthier foods, fruits and vegetables. Actually, Jordan knows this well. We actually did a practicum at Stanford Law School last year to look at ways that the county could develop policies or programs to improve nutrition, and a lot of the programs that the students came up with had to do with creating access to healthy foods to the lower income communities, such as, getting corner stores where a lot of the poor communities purchase their foods to actually have fruits and vegetables, and to help subsidize it so that those fruits and vegetables are actually economical for people to buy. Another program is sort of trying to bring farmers markets into lower income schools so that children and families that normally don't have access to fresh fruits and vegetables actually get them. And I think what's clear is that it has to be a multi-pronged approach, because unfortunately the problem is multifaceted.
The end point of my cases is not just money back to consumers who bought these products, but the more important long-term effect is a label change. There are, Jane pointed out on this cover Chobani yogurt, the sweeteners listed as evaporated cane juice. There's 8,000 products in the supermarket where evaporated cane juice is listed as the sweetener. And the reason that's a problem is that 100 years ago, the average American consumed 2 to 4 teaspoons of sugar a day. Today, the average is 22 to 24 teaspoons of sugar a day. Your body does fine on 2 to 4. But 22 to 24 a day, you're not biologically built to process that much sugar. And most of the sugar that all of you are consuming, you're not consciously spooning it in your iced tea. It's hidden in packaged foods that you think are healthier than Coke. That's got to change. When we eventually beat Chobani, and they are clinging to this, you would think, why don't they just change it? Why don't they just call it sugar? Because calling it evaporated cane juice increases sales. When you buy a donut, you're expecting the different. When you buy a cup of Chobani yogurt, you think you're having a healthy breakfast. And they've done the market research on this. So the end point of my case is going to be a label change. Dole will no longer call this all natural fruit. The sweetener here will be listed as sugar, and Pam will list propane and butane instead of propellant. Truth in advertising.
For those of you who litigate, I was curious what you think about whistleblower lawsuits, False Claims Act, either at the federal level or at the state level, particularly as a way to get around preemption, because even if you can say that a federal scheme basically preempts the field in terms of what your product needs to say, False Claims Act would basically allow you to say, well, we've contracted around that to a higher default rule with our providers, and they've violated that either in the way they've raised their food or the way they've labeled it. Is that a path around preemption?
So yes, under the False Claims Act, somebody who is a whistleblower within a corporation can file a lawsuit on behalf of the United States if the whistleblower has witnessed what he or she perceives to be fraud on the government. So there was a case where the Humane Society had somebody inside what was the name of it? A big slaughterhouse. Yes, a big meat company that had huge programs to sell lots and lots of meat to the federal government for the National School Lunch Program. And the Humane Society had a whistleblower tucked inside the company. In the contracts with the federal government, the meat producing company promised that the meat would be humanely raised. And in fact, it was not humanely raised. It was raised in the same way that all other factory farm meat is raised, which is anything but humane. The Humane Society filed a False Claims Act lawsuit, also called a key tamlin lawsuit, on behalf of the United States, claiming that the United States had been defrauded into purchasing all this meat that it thought had been humanely raised, and then passing this meat on to the children in the school lunch program. And it was a great case, and the United States came into the case and litigated it on its own behalf, and it was a great result. The problem is that as good as that case is, it's a very limited sliver, because when you're trying to go after factory farms, there's only a very small number of them that have direct contracts with the federal government. And unless there's a direct contract at issue, then the key tamlin Act doesn't apply. So it's a wonderful mechanism, and it's yet another reason why it's so important that these ag-gag statutes are declared unconstitutional, because unless you can have whistleblowers, you can't have those sorts of actions. But it's just a very limited tool.
Yeah. Are there state, county, or municipal contracts that could be the source of litigation?
It's actually, I think as Lustig pointed out, it can be very difficult to bring those False Claims Act cases, especially establishing damages. It can be very difficult. What we found to be a better way for us, at least, to attack these types of practices is to use either the unfair competition law, which is California State Consumer Protection Statute, or the false advertising law, because those statutes are ones where the government doesn't have to show injury. Also, the scope of proof that the government needs to prove is much less. We just have to prove that a consumer is likely to be deceived. We don't actually have to prove that the consumer has been deceived. And the relief is pretty broad. You can get injunctive relief, you can get restitution, and you can also get civil penalties. And this is a strategy that San Francisco has used very heavily as part of their affirmative litigation, and so does Santa Clara. There's actually a current lawsuit that San Francisco has filed against Monster Energy drinks using the unfair competition law, which really focuses on their sort of improper marketing to children, as well as the sort of really insidious viral and social media marketing campaigns, which really tie these drinks up. I have to admit, when I used to go clubbing, I used to drink Red Bull and vodka. It's just what you do, right? But it's very insidious, and actually the studies show that it's, when you combine alcohol with high caffeinated energy drinks, it's very, very bad. I regret it. Those type of lawsuits are really sort of the bread and butter for public prosecutors, the state attorney general, and they provide a route that governments can take to attack this through litigation that a lot of private parties can't take advantage of.
I saw you nodding about, caffeinated alcoholic beverages, and that seemed like an instance in which our regulatory apparatus really quickly responded and made all these companies remove caffeine from the beverages. Did they just not have sufficient lobbyists, or what was responsible for that?
Well, it's not the caffeine and it's not the alcohol, it's the caffeine plus the alcohol.
Right.
But, you probably heard about the 5-hour energy pills, okay, having caused arrhythmias, so that's now being litigated as well. Bottom line is, it doesn't affect everybody, but it affects certain segments of the population. And the question is, which population does it affect? Example, see this stuff here? Latinos are 3 times more likely to develop non-alcoholic fatty liver disease than our Caucasians or African Americans after drinking one of these. We have the data on why, and we have the data on how. The question is, what about failure to warn? So should we put here, Latinos may cause fatty liver disease? Well, in fact, we tried a soda labeling law. Monty introduced it, SB 1000, and it was kicked out this past year. So these are, things where the science really makes a difference. What about strict liability? Is this a defective product? Yes or no? Well, actually, if you use the criteria for a defective product that the industrial industry uses, it would be. But because it's food or considered food, it's not. The question is this a food? Is this a nutrient? Is there any nutrient in it? There's no question the sugar is an energy source, but is that a nutrient? Can anyone name me an energy source that's not a nutrient? Alcohol. Okay? 40% of America are teetotalers. They don't need it. 40% can pick up a drink and walk away from it, but 20% are alcoholics, and it's completely not necessary. It's an energy source, but it's not a nutrient. Well, sugar is an energy source, but it's not a nutrient. Is there anything else in a can of soda that is a nutrient that you need? No. So is this a defective product if it actually hurts you? And there's nothing in it that is redeeming. In fact, it is. The question is, why are foods excluded from strict liability statutes? These are all questions that have to, ultimately be litigated and brought up. And then finally, the last one is parents patriot. The state is the parent. That's how the Mississippi Attorney General broke big tobacco. Was suing on behalf of the state, because the state was not a nominal party, it was his own party, for recoupment of Medicaid costs relative to lung cancer. Well, could we sue, for instance, soda companies for development of diabetes, for recoupment of Medicaid costs related to diabetes? I've just shown you that sugar is approximately the cause of diabetes. Could the state sue? The answer is absolutely. And there are at least 2 attorneys general that are looking at this right now. You go. Doesn't mean they're going to do it, because those are elected officials. They can get themselves in heat hot water if they do. But they're looking.
I have a question. So if you ran the world, what
My wife would be very unhappy.
you and your wife rule the world.
But she'd be very happy.
What would you do about sugar?
We have to reduce availability. Okay? Sugar used to be a condiment. Now it's a diet staple. It became a diet staple because we took the fat out of food. We took the fat out of food for completely inappropriate reasons. Okay? We also changed the subsidy structure. Back in the 1970s, we told the agriculture community we were not going to reward them on the basis of quality anymore. We were going to reward them on the basis of quantity, very specifically to lower food prices. And that's what created these CAFOs, was the idea that you could actually increase productivity by growing all the corn in Iowa and putting all the meat in Kansas. Okay? And that did lower food prices. The problem is we're paying for it on the other end. Think of it this way. The food industry grosses $1 trillion a year. Healthcare costs in America are $2.7 trillion a year, of which 75% are chronic metabolic disease, of which 75% of those are preventable. So when you do the math, that's $1.4 trillion a year down a rat hole that is unrecoupable due to the diseases that the food industry is creating. This is unsustainable because there's more money going out than is coming in. And that is why Medicare will be broke by the year 2026. So as long as we keep doing what we're doing, we will not have a healthcare system. We do not have a choice. And we know where the problem is. The only question is, what's the best way to litigate it, regulate it, educate it? And that's what we're all still trying to figure out.
And keep in mind, meanwhile, that antibiotics won't work by that point.
I'll open up for questions, because we only have 5 minutes
One
remaining.
thing, I have one thing to say. Humanely raised and natural don't mean anything, don't believe it. That's all.
Yeah, we'll start there.
Hey, quick chime in on the question about rapid regulation of like 4 Loco and 5 hour.
Yeah,
I think those kill people quickly, so they get a strong regulatory
That's
response.
right.
There's
No,
actually
you have a very good point. If you look at the Food, Drug, and Cosmetics Act of 1938, their job is acute toxicity. It says so right in the charter. Chronic toxicity, that is long-term issues, that's called pharmacodynamics. And that is not in the charter, and that's actually a very important point. The FDA doesn't ask for those studies. The food industry says, well, they can't help our sales, why would we do them? And the NIH says, well, it's not our compound, why would we pay for them? So we have no data on any of the pharmacodynamics. That's why it took so long to do. That's what tobacco did behind. That's exactly why the FDCA could not regulate tobacco, because it was a chronic toxicity. One cigarette doesn't kill you. In fact, 100 packs in one day doesn't kill you, is what happens long term that kills you.
Thank you. I wanted to ask a question on the historical context of tobacco, because if I look at who's ringing the bell the loudest on the good science here on metabolic disorder, it's you, it's Gary Taub, it's Nina Teicholz. The last two are citizen scientists. I mean, they're not really even affiliated with a formal organization. The government is decades behind on this. And part of that is because, you know, the doctrine was the bad science that came with the cholesterol and heart disease debate, which was decided in its institutional by very bad scientific studies. That's now being disproven. The field of cardiology is coming around, but like, who needs to come around for sugar to be revealed in the public sphere to be as bad as it is, and can they kick the can down the road and obfuscate for decades more?
Oh yeah, oh they can, and they are. Let me give you an example, okay? I am on the board of directors of the Bay Area American Heart Association. The AHA came out very specifically in 2009 and said, this is a problem. And that's why I belong to the AHA. I'm an endocrinologist. You know, what the hell am I doing on the AHA board? Okay? But the fact is, they know that this is a problem. This is causing heart disease. And so I do sugar, and they do heart disease, and sugar causes heart disease. We got it. The American Diabetes Association completely discounts this entire thesis. Why? How come the AHA says sugar is a proximate cause of diabetes and heart disease, and the ADA says no such thing? Why is that? The reason is because the ADA is about treatment. And the reason the ADA is about treatment is because they get their money from Big Pharma.
Ah, yes.
That's why. The International Diabetes Federation, which is the diabetes association for the rest of the world, is all over this like a wet noodle. They get this because their countries can't afford these expensive medications. They have to prevent it. So they are saying, yes, sugar is the most actionable and targetable issue in our diet to try to fix the problem of diabetes. The IDF, the ADA, they've actually come out and said, we do not think this is a problem and we are not going to investigate it. Why do you think that is?
We're going to take this question up here.
I would like to know what is your opinion about diet products?
You know what? Let's hold that for after. It's a separate issue.
Yeah.
I'm actually curious about the preemption question. So I'm wondering if it's actually better for the state to pass or not pass, these laws when they do preempt certain local governments. But at the same time, it seems like there's a whole lot of local governments that would do absolutely nothing on nutrition if the state didn't mandate them. So I'm curious, is there a balancing act?
Yeah, when we look at what sort of regulations we're going to pass when we evaluate the legal challenges, part of the motivation is not necessarily to have the law go into effect. Part of the goal is to draw attention to the issue and also change the debate. Because one of the things that we find from a policy standpoint is where you make the goalposts makes a big difference in terms of where the policy goes. And sometimes, San Francisco in particular, and Santa Clara, will pass laws knowing that they are vulnerable to legal challenge with the understanding that it brings such an important point to the nation and to the community, and we want to shift the goalposts in terms of where appropriate policy would lie. And by passing a regulation that we know that's going to be challenged and could likely be invalidated, we hope to change the public debate.
Okay, just one quick follow-up. So isn't preemption a success? I mean, isn't the fact that a local government forced a company to try to seek a state law that preempts it, perhaps weaker, but still a law on a state level or federal level, is not a success?
Yeah, and ultimately we probably consider the menu labeling ordinance, for example, a success because at least nationwide there are restaurants that now put their calorie counts on. But it's always sort of a balancing act, right? Because it really should be much more, but you try to get the victories that you can.
If you want to read in one case one source, the very best analysis of preemption in the food labeling arena. The case is named Brazil, B-R-A-Z-I-L versus Dole. Dole, remember those guys? Judge Chou wrote a very detailed, very scholarly analysis of preemption in 2012, explaining why California's food labeling law, the Sherman Law, is not preempted by the Federal Food, Drug, and Cosmetic Act. That should be your starting point if you're interested in the topic.
We have time for one more question, George. All right, Sue.
I'm wondering if there is any strategy using methods when you're going after things like labeling, for example, if I'm going to cane sugar, unlike Compel, there's a lot more widespread use on all the products. So is there a strategy in taking Chobani with another farm?
Yes. Chobani is the fastest growing yogurt company in the world. They are enormous. They are very successful. We're not suing mom and pop businesses. We're going after Conagra, Unilever, Hershey, Ocean Spray, Welch's, Nestle, the biggest food companies in the world, because if you can get them, see, the reason it's a very competitive marketplace out there, nobody wants to change their label because then that places them at a competitive disadvantage. So you go after the big guys first. If you can force them to change their label, then the smaller guys will follow suit. A lot of these companies have already started changing their labels, which is a good thing, good for them.
All right, thank you, everyone. All right, thank you to our panelists.